Good morning, everybody. I'm Rebecca Fox, and Michael and I are going to be speaking to you today about what's on the overview slide, which is coming up. And we're going to talk about non-compete clauses. I hope you're all here to hear about that today. So what are they and how are they used? Then the enforcement and going through some case law, settlement agreements and the use of non-compete clauses within those settlement agreements, and the future of non-compete clauses. So looking at the government consultation. So what are they? They are set out on the next slide, a clause preventing an employee joining a rival employer for a defined period after termination. So often they're in contracts of employment. An employee will start, they'll sign a contract, and within there there'll be restrictions, and these restrictive covenants can contain non-compete, poaching of staff, non-solicitation and non-dealing clauses, amongst others, and non-compete are an area of restrictive covenants where it's stopping somebody, an employee, joining or setting up in competition. Because of the impact on that member of staff, so they cannot for a certain amount of time, often reduced by garden leave, then can compete and go to another business, and they've been traditionally harder to enforce than other restrictive covenants. So they come under a lot of scrutiny and a lot of criticism, and often people will say, well, they're just unenforceable, and there's no point to them, or well, we're not going to be able to enforce this. And that is the starting point with a restrictive covenant, and the courts take the view that the starting point is that they won't enforce anything that restrains trade. But they then will look at whether there is a legitimate interest to protect, and whether that protection is reasonable in the circumstance, and if those two limbs are met, then it may be enforceable. So on the next slide, there's set out information about how they're used. So they're often in senior contracts as a standard, and they will be signed in that contract of employment, and then when it comes to trying to enforce them, often we find that they might not be reasonable in the circumstances. There isn't that business interest to protect in the way that they have been drafted, and we find that often clients will say, well, that's okay because they have a deterrent value. And even when we're starting off that drafting at the beginning stages, sometimes clients will say, well, even if they're not going to do what we ultimately would like them to do, that employee may think that they will be enforceable, and therefore may stop them competing on departure. And that if they're then challenged on that, then they accept that they will not be able to enforce it. We often find that we get instructions to draft a template document, and what we always say is that, don't be a slave to that template document. Always they should be looked at, revisited, and seen whether they are reasonable in those circumstances for that individual. And on the previous slide, there was that quote from Lord Justice Underhill in a famous case where he talks about these non-compete clauses being the most powerful weapon in an employer's armory, because they can be, and especially when you're entering into a new contract with an employee, and that employee has very little bargaining power. But if used correctly, they can be enforceable. In that case, actually, the employee started as a fairly junior member of staff and had restrictions that nobody argued with the fact that those restrictions at the point that employee started would not have been enforceable. when he was initially hired, but he was promoted several times in the subsequent years and was ultimately appointed to an executive level position that entailed substantial responsibility. So at the point that he left, the employer, the company was saying, well, actually, these should be enforceable now. Given his status and responsibilities at the time. But those restrictive covenants essentially couldn't be saved because the employee had promoted. Because if those restrictions are void at the point that the contract is entered into, they cannot be revived. Well, often cannot be revived, I should say. And so it's really important that when staff are promoted, that they are given new contracts of employment, that they're not just provided with a contract, a letter which is set out their new position, new salary, so that you can show that it reflects that any restrictions and non-compete have been thought out in respect of that individual, and that you have a legitimate business interest that you're trying to protect. And in those circumstances, in the right circumstances, restrictive covenants can be extremely helpful. And Michael is going to go through the enforcement of those restrictive covenants of non-compete.
Right. When I'm asked to advise on the enforceability of restrictive covenants, the first thing I do, whether I'm acting for an employer or an employee, is obviously look at the clause, and in particular the way it's been drafted, because on many occasions, when you actually start reading what is actually written in the contract, it doesn't always make grammatical sense. So that's the first problem. And also, secondly, what is the employer trying to protect? Is there a good reason for the imposition of these covenants? Because as Rebecca was saying, the starting point with a restrictive covenant is that it amounts to an unlawful restraint of trade and potentially not enforceable. But however, non-compete clauses, in my view, are making a comeback, provided the way they are drafted is no wider than reasonably necessary to protect legitimate business interests. And the legitimate business interest that the employer is trying to protect is obviously the trade relationships that it has with its clients or customers. And also, you need to look at the terms of the restriction in terms of its scope and duration. And again, as Rebecca was saying, the covenants are judged at the time the parties enter into the contract of employment, not at the point where the individual is actually leaving. And so what is the employer trying to protect? And on the slide there, you'll see I've outlined 3 potential areas: confidential information, trade secrets, and customer connections. In one case, involving Dyson, which happened a couple of years ago, they had an engineer that basically was working on a very top sensitive project, which was the development of an electric car. And the engineer was proposing to join a competitor, I think it was Tesla, and he was subject to a 12-month non-compete. And the court held, because of the sensitivity of the project on which he was working, it was necessary and it was reasonable on the part of the employer to actually enforce those covenants. Also, as well, I do find that in many cases, employers do actually impose restrictive covenants on junior members of staff, and it's wholly inappropriate to do so. And again, I recall a case a couple of years ago where it was a recruitment agency, actually, they imposed very onerous restrictions on a very junior member of staff. And that junior member of staff did actually, over a period of 10 years or so, rise through the ranks and became very senior. And she decided to leave. And the difficulty the employer had in that particular case was that the covenants that were entered into at the time that she joined were wholly unreasonable, given the fact that she was a junior member of staff, had no business or client contacts, and therefore they were unenforceable. What I'm going to look at here is a case of Law by Design versus Ali, which is the latest case on non-compete clauses, where the court, for the reasons which I'll go into in a moment, did actually uphold the non-compete clause. And that case followed in the heels of another case called Tillman and Egon Zender, which related to an executive search firm where the CEO was subject to a 6-month non-compete. And again, the covenant of the non-compete was upheld in that particular case. So whilst in the past there has been difficulties in enforcing non-compete clauses, there is now some case law again emerging over the last couple of years, which again, as I was saying earlier, that the difficulty is that provided the covenants are drafted particularly appropriately, then they should be enforceable. But anyway, dealing with law by design and Ali, what happened in this particular case was that Miss Ali was a senior solicitor for a boutique law firm, and she'd been employed for about 7 years. She'd signed a contract of employment not to compete with her firm for 12 months after the ending of her employment, relating to the parts of the business to which she was involved with to a material extent. She practiced in the field of employment law and also with particular expertise in the healthcare sector. 2 years later, she was actually given a 3% shareholding in the business and also signed a shareholder agreement, which also had a non-compete for 12 months relating to any part of the business, including parts of the business to which she wasn't even associated with. And what actually happened in Ali, she decided to leave, she gave 6 months notice, and the employers objected to her joining a competitor. Within the contract of employment, she also had a covenant not to solicit the clients and not to deal with the clients for 12 months. But what actually happened in that particular case, although she gave an undertaking to the employer that she wouldn't deal with the clients or solicit them during the 12-month period, the employer wasn't satisfied with those assurances that were given. And also it became apparent that Ms. Ali, as is common when people are looking for new jobs, had actually prepared a business plan for the new employer. And within that business plan, she had told the new prospective employer that she was proposing to migrate the client base over to the new employer, and also gave an indication of the revenue that she expected to generate for the new employer. And I think it was on that basis that the court decided that there were legitimate business interests here to protect that couldn't have been protected by the undertakings that she had given in relation to not soliciting the clients, because she clearly did. She clearly put together a business plan setting out her intentions. And also the employers were able to show, I think, on that basis, that it was necessary to have a non-compete, because the policing of the non-solicitation and the non-dealing with the clients would have been very difficult indeed. One other point of note, interesting note in that particular case, although the non-compete in the contract of employment was upheld as being enforceable, the covenant in the shareholder agreement, which essentially prevented her from competing at all with law by design, was held to be unenforceable because it went too far. So in that particular contract, the court had held that that was clearly an attempt to stifle any competition by Ms. Ali at all. So I think you have to look at this case in the round, whereby if you have an employment contract and you're trying to protect your legitimate interest, what is it? Essentially, in this case, it's the client base which Ms. Ali serviced. And if you go beyond trying to protect a wider client base, which Ms. Ali would have had no contact with, then again, in those circumstances, the clause will be too wide and unenforceable. Contrast that with the case of Quilter, which involved a financial advisor. And again, a non-compete clause was held to be invalid. And the reason it was held to be invalid was as follows: that she was a relatively junior member of staff. She joined Quilter and she left the company after 6 months. So therefore, would not really have been in a position to develop client relationships, unlike Ms. Ali, who'd been employed for a number of years. And she had, there was a 6-month probation period, and she left within the probation period. There was no evidence either that when she joined the organisation that she would be promoted. So again, the court looked at whether the 9-month non-compete was reasonable in the circumstances. The other point as well of note is that although she was prevented from competing for 9 months, she could compete with Quilter in areas where Quilter didn't operate, but Quilter has a national branch throughout the United Kingdom. So again, what Quilter were trying to do were to impose restrictions that went beyond protecting their legitimate client base. And I think the other point to note is that in Quilter, the employee only worked out of one branch office, and had the covenant restricted her maybe from operating with clients or dealing with clients out of that branch office, then the clause may have been enforceable, but it went beyond that. And also as well, I can say from experience, I had a case last year in the High Court where again there was a geographical non-compete restriction for a period of 6 months in the term, in the case of one employee, and 9 months in the case of a senior employee. And again, there was a deliberate breach of those covenants, which were actually upheld as being enforceable after a 2-day hearing. Again, speaking from experience, the covenants in that particular case, again, were relevant to those people to which they were subject. So when you're drafting these restrictive covenants, as Rebecca was saying earlier, don't just use a template and apply that formula to every member of staff. It just doesn't work. Restrictive covenants have to be viewed and judged in relation to the role that the individual is undertaking. And also you look at the position of that particular person within the business. What are you trying to protect? In the main, it's going to be the trade customer base, client base. Is the restriction suitable and reasonable? Obviously, the more contact you have with a customer or a client base, the more senior you are within an organization, then it's more likely to be reasonable, provided you draft the clause in such a way that you are protecting the client base to which the individual had contact. Also, if you are promoting an individual, again, you might want to modify the restrictions. In the case I was talking about, one of the arguments that arose in the High Court was that the restrictions had been changed in the case of one particular individual who was subject to more onerous restrictions. And they were trying to argue that they hadn't agreed to those covenants and they were unreasonable. But what the judge found in that particular case was that at the time the employer and the employee were negotiating an increase in the scope of the covenants, the individual wanted a higher spec car than he would normally have been entitled to. And the judge held that that was adequate consideration for entering into the new covenants. So the other point as well, the final point I think I'd like to make as well, within any well-drawn contract of employment, you should also have a garden leave clause. So if the individual is senior and if they give notice, then it's something you can consider as an alternative to a non-compete. You can put them on garden leave for the period generally of their notice. So thereby keeping them out of the business, keeping them out of the sector, and giving you an opportunity of bolstering your connections with your clients. But of course, the downside in taking that action is, of course, you will actually have to pay the individual for the garden leave period. And I think the other point to note is that if you have a restrictive covenant, say for 6, 9, 12 months, then if a person is put on garden leave, then I think that period of garden leave should be taken into account for the purposes of enforcement. So I'll hand back to Rebecca.
Thanks, Michael. It's interesting hearing about the case from last year, remembering that case, because actually we deal with a lot of these cases right from the beginning before we know there is ever an issue. So we're often involved in the drafting of those restrictive covenants, and then when a senior individual leaves, then we are instructed on enforcement of those restrictions, and in that case, go through that whole process to then managing to enforce those restrictions, and then the last bit of that process is often a settlement agreement, sometimes after enforcement, or often a settlement agreement when an employer and employee decide to part ways, and it can be from any number of reasons that a settlement agreement is entered into, excuse me. And it's at the termination of employment usually, and what a settlement agreement does, it's a legally binding document where an employee will agree to waive any claims that they may have against the organisation, and in return a sum of money is paid, and there are several clauses restricting, so there'll be confidentiality clauses in there, a gagging clause in there, a return of property clause, and often in settlement agreements are restrictive covenants, so you'll find perhaps a non-compete clause. Now, sometimes these covenants are repeated from the contract of employment, and sometimes they're brand new restrictions, and there's several reasons why you might do one or the other. And one is that if they're not in there and you have them in the contract of employment, and there is what we call an entire agreements clause in your settlement agreement, arguably the restrictive covenants do not continue, because you're saying that this is the only document between the parties and we're not relying on anything else, and so you'd want them copied into that new document. The other is that if you are relying on the ones in the contract, with and there isn't an entire agreements clause, but there's been some sort of repudiatory breach by the employer, even though they can't bring a claim against them, there arguably those restrictive covenants will not survive termination, and so we want to not have any of those arguments and make sure it's really clear in that settlement agreement. Sometimes we find that we are instructed to draft settlement agreements where there are restrictive covenants in that contract of employment, but actually we want to now tailor that to this individual, and perhaps there's generic restrictive covenants, and we want to put these restrictions so that they are more suited to the individual that's leaving, and much higher chance that that individual is going to adhere to them and agree to them in that settlement agreement. If there are brand new restrictions, then there needs to be new consideration, so something in return for that. Usually it's a nominal sum, and that payment for the restrictive covenants will be subject to tax and national insurance, and it's really important that there is that consideration, because HMRC might decide if there is not something carved out specifically, they could argue that if there's a termination payment, that whole termination payment is in relation to those restrictive covenants, and then that entire sum could potentially be taxable. So you get this £30,000 that's tax free. You pay up to that sum to a member of staff who's exiting, and there's no consideration in relation to any restrictive covenants, then HMRC could decide to tax that payment. And then we're looking at issues there in relation to tax indemnity, so who's paying that tax, and to make sure that those clauses within the settlement agreement are really tight and very clear in respect of who's paying for that tax. And on the next slide, talks about enforceability. So what happens when the employee perhaps breaches the restrictive covenants in the settlement agreement? Well, the same general principles apply that Michael's talked us through there. But when an employee breaches, the employer could seek to enforce those terms and seek damages by bringing a breach of contract claim. And although the same general principles apply, different considerations will come into play when enforcing these restrictions, because at the point that you enter into a settlement agreement, the parties have far more equal bargaining power. And because when an employee starts a new role, there is very little or perhaps no bargaining power in some situations, and therefore you will accept whatever is in that agreement because you want to take on that role. However, not only is it much fairer in terms of bargaining power, both sides will have legal advice, more often than not both sides, but it is a requirement for the employee to have to take independent legal advice in order for that settlement agreement to be binding. And therefore it's they've had that advice as to the terms and effect of the agreement, which will include the terms and effect of those restrictive covenants. And also the public policy point that the terms on which a dispute is settled should be respected. So depending on the circumstances, that employee may no longer be considered to be in an unequal bargaining position, but able to decide freely upon whether they wish to enter into that restraint which is set out in the settlement agreement. And also, it is more likely in those circumstances that they're going to be tailored more specifically to individual circumstances, and therefore more likely to be enforceable. The courts don't really want to get involved. They'll be reluctant to revisit those terms to see when a party seeks to challenge the reasonableness when they're set out in a settlement agreement, when they've entered into them with the benefit of legal advice. And Michael's going to talk about the future of non-compete clauses and what that looks like.
Thanks, Rebecca. The topic of non-compete was the subject of a government consultation, which started actually in December 2020, and it ran up until the 26th of February 2021. Unfortunately, there is still no outcome as to what the government's intentions are going to be. And also, as the slide says, the government sought a number of views on whether non-compete clauses should only be enforceable where essentially the employee continues to receive their salary and benefits for the restricted period, or alternatively banning non-compete clauses altogether. In fact, in the state of California, they have actually banned non-compete. They're unenforceable in that particular state, but obviously we operate under a different legal system here at all. But I suppose one of the issues that this consultation possibly throws up is that if the government, for example, introduced legislation which provided that a non-compete clause was only enforceable if the employee received their salary for the restrained period, do you or should you at this stage be considering reviewing your restrictive covenants? But of course, many employers don't actually want to pay their employees who've decided to leave for a period of non-compete. So that's something you need to grapple with. I guess the alternative solution would again be you'd have to put the person on garden leave if there was a garden leave clause. Banning non-compete clauses altogether, I don't see that at the moment. There was a consultation about this similar issue, I think it was about 10 years or so ago, and the government at that stage didn't introduce legislation which banned non-compete. But again, I think going back to the fundamental point in all this, when you are drafting these covenants, do consider, is it necessary? What are you trying to protect? Look at the individual, look at the role that they are undertaking, and impose reasonable periods of restraint, and don't slavishly impose the same formula on all your staff, or otherwise you will actually fall foul and you won't be able to enforce. And I think the final point of note as well, that if you as the employers breach the contract of employment possibly as a result of the way in which you treat your staff, then it's likely that in the case where there is a breach of contract, and that breach of contract is accepted by the employee, then it's likely that the covenants that you wish to rely upon will not be enforceable. Because at the end of the day, you must remember that the decision to enforce a covenant or not is very much in the discretion of the High Court judge. So again, if you breach the contract, then a judge is not really going to have a lot of sympathy with you as an employer if you're trying to impose restrictions which on the face of it may be unreasonable. I mean, that's all I've got to say, but I see that there are a couple of questions in the chat box, but unless Rebecca, you want to say something else first.
I just wanted to quickly touch on a new e-learning series that VWV have put together called HR and Employment Law for Managers. It's not just for HR, it's to upskill all line managers, and it includes a 9 series short courses of covering all legal areas which are set out there, and it's available with any e-learning solution subscriptions, starting at just £600 a year. Really excellent feedback we have had from our clients in respect of these courses, as a general overview to all these areas. And if you are interested, on the next slide, if you'd like us to get in touch with you, please do vote now and let us know whether you would like us to contact you and give you some more information about that. That's just on VWV Plus. And yes, there are a couple of questions. I'll just give you a minute just to finish that poll. It's telling me it's in progress. And if anyone's got any other questions as well, we'll answer these couple that are in here, but if anyone's got any other questions, then please do send them in. I'll start answering these questions. So one of those is, did you say settlement agreements up to 30k are not subject to tax and national insurance? So yes, I did say that, and the answer is yes, you can have, as long as it is genuine compensation for the loss of somebody's employment, then you can have up to £30,000 tax-free. It doesn't actually have to be in a settlement agreement, but it would be prudent to do so if you're going to paying out sums of money. It's misunderstood in relation to notice payments, that often people will say to me, oh, but we can pay the notice tax-free because it's still under the 30k. You can no longer do that. Notice payments are contractual payments and must be subject to tax and national insurance deductions. But if you are paying additional payments on top of that, up to £30,000 can be paid free of tax and national insurance. And the other question, is it prudent to adapt the compete clause in their statement of employment as employees rise up the business? Yes. What if they don't agree with the changes? I would normally do it at a stage where you are going through pay rise time or promotion period, so that you are ensuring that they're benefiting from it as well. There is also consideration there, and somebody is more likely, if they're going through a promotion process, to want to accept that new contract. Anything else to add there, Michael?
Yeah, just a couple of points there. Where you are varying the restrictions, it is, at the end of the day, a negotiation. And I've just finished helping a client in a negotiation where that particular individual was promoted essentially to CEO. And the restrictions then, obviously, that were going to be imposed on that individual were more onerous. Obviously, the trade-off was that the potential salary that the individual was going to be paid was considerably more than what he was getting. But if the relationship turns sour, as sometimes these relationships do turn sour in the future, then it will be more difficult for him to essentially unravel his relationship with his employer, which in this particular case will involve him not competing. I think it's for a period of over a year, and also not being paid out on bonuses for 2 years, etc. As I said to him, it is a negotiation. Do you want the job opportunity and the remuneration that flows with it, or not? So that's really all I want to say on that. But it can be, it is a balancing act.